Right, we're reconvening, it's 1:05. Yes.
I had one comment based on the last group, particularly with the intriguing suggestion that Darren made about looking at hydrologic cycles and thinking from a climate perspective that doing a survey on the cost of service is really focused on the now, not on the future, not on future costs that might be associated with prolonged drought or whatever. And so what the energy agencies do is they determine a marginal cost for the next increment of water that's needed. It might be recycled water, it might be recycled water and stormwater or something like that. And that's the cost then that they look at over a 10-year period or over some larger period.
So it is a longer period of time.
It's a longer period, and it's looking to the future, not looking to the present or the recent past. And so I think as we think about what to do, and the piece to help us along, the PUC is, I think they have a workshop tomorrow on this calculator that they're working on for determining whether or not some investment by the energy companies is cost effective if they invest in a water project. And they are looking at marginal costs there as well. So anyway, we should probably try to tap into that.
And in the spirit of sharing information, let me just share some information I received from our Division of Drinking Water, that they've actually been collecting water rate and water costs annually as part of the water system's annual report since 2012. Wow. So we do have a rich database that we haven't tapped into that could also serve as a vehicle for obtaining additional information. So that's courtesy of our Division of Drinking Water.
Yes, thank you, Chair Marcus. I am pleased to introduce our third panel today. Over the course of the last 3 or 4 months, as the board has started to engage on the issue of water conservation pricing, I have repeatedly told both outsiders as well as all of you that we are doing our best to get up to speed in an area of the law that is fairly complicated. And right now, you and the people listening on the web and the people in the room here are privileged to hear two of the most experienced practitioners in the world of Proposition 218, Kelly Salt and Michael Colantuno. I encourage you all to engage heavily with them on the legal questions you've been asking me and my staff over the last couple of months. They are not only knowledgeable, but they're also very forthright in their answers and very eloquent speakers. And they have a set presentation that they are going to provide that provides some of the context not only for the San Juan Capistrano decision, but how it also interplays with a number of what I will characterize as competing cases in the area of water conservation pricing and Prop 218 compliance generally. And without that, I'll turn it over to the two of them.
Good afternoon. I get to start. My name is Michael Colantuno. I'm a local government lawyer. I represent rate makers at typically the retail level, but occasionally the wholesale level, and I do water, power, trash, etc. I'm not speaking for any of my clients today, but I do want to be upfront about the perspective that I bring to this work. So our goal is to think about how we might use pricing to send a conservation signal, notwithstanding some of the legal hurdles that have recently presented themselves. So you're familiar with the Capistrano case. It had 4 claims in the trial court. I was trial and appellate counsel in this case. First was that our groundwater project was alleged to be waste because allegedly met water was cheaper. Second, when making rates, we predicted our future capital needs. And rate making does look to the future. It doesn't commonly look as far out as you've suggested, but it can. We predicted our future capital costs by postulating a hypothetical bond. And we didn't sell the bond, as it turns out, because we didn't have the credit rating and the liquidity in our utility to do it. Our critics called that a phantom bond and said, if you didn't sell the bond, you don't recover your capital costs. And our response was, we still have capital costs. We're just doing it on a pay-as-you-go basis, and we still get to collect them. The third issue was, could we fund a new purple pipe system, a new reclaimed water distribution system, using the proceeds of a domestic rate? That was litigated. And then the fourth was, were our tiers adequately justified? That one you've been hearing a lot about. Only the recycled and tiered water rates were presented to the Court of Appeal. The phantom bond was abandoned in the trial court. We won in the trial court, and they didn't choose to present that issue. And the groundwater treatment plant, they abandoned in the trial court. Appropriately so in my judgment. I don't think the law is at all complicated on those subjects. I think we were well defended on that ground. So as to the two issues we did bring forward, it was a split victory, although from the headlines you only heard about the piece we lost. The court did say that funding the purple pipe system was an appropriate use of a potable water rate because developing a purple pipe supply displaces demand for potable water, which amounts to supply, and you can make people pay for the supply that you're delivering to them. I think intellectually that's a little inconsistent with the next holding, which is that we could not construct tiered rates without a much tighter cost justification of exactly which costs were being attributed to which tiers and calculating it out to the penny. We have a number of disagreements with that approach, and the one good thing I'll say about the experience of losing this case is that it disagrees with a couple of other cases, and therefore the trial courts are free to choose which case to follow, and we've already persuaded the Monterey Superior Court not to follow this case. So the court's rationale was a very narrow reading of Article 10, Section 2. Your lawyers have done an excellent job of explaining in the request for depublication exactly how wrong that reading was. The case, of course, caused much consternation here and elsewhere. The case isn't quite done yet. There are pending requests for depublication filed by your board and by a number of local government associations. There have been responsive letters filed from some of the litigants and some of the libertarian interests in the state. It's pending in front of the Supreme Court. There's no deadline under the rules. I had a request for depublication pending there for 6 months on one occasion, although I would anticipate we'd hear sooner than that. What happened next? The City Council voted to withdraw their petition for rehearing, in part because the new City Council is more sympathetic to the plaintiffs than the old City Council was. The requests for publication are pending. We had some discussion at the time about the possibility that the Supreme Court might take the case on review without a petition from a party, but the time in which that could have occurred has run and it has not occurred. I do have another case that I'm handling called City of San Buenaventura versus the United Water Conservation District, which is a dispute about groundwater augmentation charges in coastal Ventura that the Supreme Court did grant review on, and that raises some related issues, and we'll have some dialogue with your staff about whether some form of amicus participation from this board or other interests might be appropriate in that case. So if San Juan is the law, and as I told you, we persuaded at least one trial court already that it's not, what are rate makers, retail rate makers' options? One is use flat rates and fines. That's one way to attain conservation, command and control. Ironic that a libertarian-inspired case would produce that strategy. Second is that you can carefully cost justify your tiers by doing the analytical math that the judge asked of us. The problem with that strategy is it's a rare utility that has a cost structure which produces a price curve which produces the conservation signal that you want. The math was done on the San Juan Capistrano record, and it suggested we would get a 50-cent gap from the lowest tier to the highest tier in a very affluent suburban district where 50 cents HCF is just not much of a price signal to conserve. You can get 2/3 voter approval of non-cost justified water rates as a tax. Good luck with that. And then investor-owned utilities can impose tiered rates, and we can sell or lease our systems to investor-owned utilities. And maybe that is a rational libertarian response to the problem of public goods. I don't know. Before San Juan came down, the lawyer who had brought that case brought identical cases in Glendale and in an agency in San Diego County called the Sweetwater Authority. The San Jose case is actually a different issue. Both of those cases are sort of hanging fire, waiting for the Supreme Court to resolve the request for depublication in San Juan. Once that's cleared away, we'll move forward in those cases. I'm defending the Glendale case, and I think we have a fine record in which to litigate, even if San Juan is the law. Kelly's firm is representing the Sweetwater Authority in that case. Because San Juan got so much media attention, and because my partner and I lost a couple of cases in the Supreme Court in 2011 and 2013 that allow a class action remedy against local government revenues, this issue has caught the attention of the class action bar. The Marin Municipal Water District is defending a class action challenge to their rates, and a number of other utilities, which for their own protection will go unnamed, are on the receiving end of public records requests that feel like precursors to litigation. So we anticipate a lot more litigation coming. The bad news is that we'll have to take ratepayer dollars to defend these cases rather than to serve water supply and conserve water. The good news is that one or another of these cases is going to find its way to the Court of Appeal, and we'll have another chance to take on the San Juan issues if the Supreme Court doesn't publish it. You'll tell me when I'm done. I'm done. Okay. There's been some discussion about a legislative fix to a constitutional problem, which is sort of a contradiction in terms. The options that are, yes, the options that are out there are the possibility of a constitutional amendment. The water quality folks, Heal the Bay and others, have been struggling with a way to get local government to fund the mandates that the regional boards have been imposing under the NPDES system, and that has coalesced in a proposal to amend Prop 218 to treat storm sewer services the same way that water and sewer treatment services are. That would be a constitutional amendment. Were that to get any traction on the Republican side of the aisle and move out of the legislature, it could be a vehicle for some of these other ideas. I don't know how likely that is, but those conversations are happening around town and around the state. Some things that the local government community has asked for is a statutory fix to the Government Claims Act to eliminate the class action threat, because that's meaningful to us, and that can be done statutorily. And then we could have a renewed statutory affirmation of Government Code Section 375, which says conservation rates make good public policy in a desert state. Our sense of what the San Juan Capistrano decision got wrong, and is it still?
We can both.
Why don't you take over?
All right, so Michael mentioned that the court. All right, Michael mentioned that the court took a very narrow view of Article 10, Section 2. Essentially, the court looked back at one legislative analysis or interpretation of the original proposition that put it before the voters, and one provision of that mentioned that waste of water shall be prevented so that water doesn't escape to the sea. And that was the court's focus, and said that that was the intent of Article 10, Section 2. It failed to look at some other provisions of the legislation, which essentially said that it's more than that, and simply disregarded it. As a result, the court failed to harmonize two constitutional provisions. Generally, when courts have two competing constitutional provisions, they will attempt to harmonize the provisions so that one is not thrown out at the expense of the other. The court also failed to look at the analysis of Bryden versus East Bay Municipal Utility District. That case, of course, was a pre-Proposition 218 case, but it still has relevance today. Essentially, what the court there did was harmonize Article 10, Section 2 with Proposition 13, Article 13A, which governs special taxes and ad valorem property taxes. And the court there said that tiered rates are appropriate because you may shift the cost to those who place greater burdens on a system. That profligate water use does create a burden on the system, and therefore it's appropriate through a tiered rate structure to shift those costs to them. They looked at that even in the concept of proportionately shifting those costs. So proportionality was a part of that analysis. The court essentially said, ultimately, it's a pre-Prop 218 case, we're going to ignore it. The court also failed to look at two other court cases, which I'm going to talk about momentarily with regard to proportionality. It took a very narrow interpretation of Proposition 218 and essentially said that proportionality has to be done on a parcel basis. In that context, they also looked at specifically sources of supply as really being the only means by which you can justify the marginal cost of water. So, thanks, Michael. So I want to talk first about what are the marginal costs of water. Of course, sources of supply are different costs, which you can demonstrate that it does cost an agency higher cost for some sources of supply than others. Also, developing alternative water supply sources are going to cost, whether it be desalination, turning brackish water into potable water. All these are going to have a higher cost to them. It's therefore appropriate to shift the cost of the higher cost of water to those who use more water. Use the lower cost of water in your lower tiers. Again, development of alternative supplies, as I mentioned, water conservation efficiency programs. But for those who use more water, you would not have the need for additional conservation programs. So it's appropriate to shift a larger portion of your cost of your conservation efficiency programs to those who use more water. Peaking costs. Essentially, when you size your system, you have to size it for peak demand. So essentially, those who use more water use place a greater demand on the systems, you have to size it for their maximum peak capacity. So those costs, essentially, you can shift over to those who place the greater demands on the system. Avoided costs. Essentially, you can look at what costs you're avoiding as a result of developing alternative supplies, your development of different supply sources, things of that nature. If you're avoiding other costs, such as higher costs of purchasing water from another source, it may be appropriate to determine what those avoided costs are and shift those over to those individuals who use more water.
So are you saying those are appropriate even under San Juan Capistrano?
In my view,
Okay, so that
yes.
fits with what I heard the plaintiff say that day to the news media.
So there are other alternatives too. You can look at using unrestricted funds. Many agencies receive a portion of the ad valorem property taxes. If you have ad valorem property taxes or if you have lease revenues, all of those revenues are unrestricted revenues. Those revenues can be used and shifted into the lower tiers to offset the cost of water in those tiers, thereby allowing for the revenues to be used for that purpose. Supplementing your existing administrative record. For agencies that are concerned about whether or not they meet the San Juan Capistrano standards, certainly you can go back and look at what your existing rate structure is. Are there other bases upon which you can justify them and supplement your administrative record in that fashion? And obviously, for many agencies who are concerned, we're recommending that they consider preparing a new and undertaking a new rate study. So the other thing we want to mention, there are, as Michael has stated, there are other court decisions that have come to a contrary conclusion than San Juan Capistrano on the proportionality issues, specifically Griffith versus Pajaro Valley, Moran versus Imperial Irrigation District, and Moore versus City of Lemon Grove. So I'm going to start with Griffith. If you're not familiar with this case, essentially this revolved around supplemental water supply program. Michael was involved in that litigation as well. Essentially what they did is they had issues with saltwater intrusion, and they developed a supplemental water supply program to deliver supplemental water to their coastal well users to act as a barrier to the saltwater. Everybody within the entire basin that pumped water was charged a portion of the cost of that supplemental water supply program. Basically, the court said that recognized that water service, and I'm just going to quote from this decision because I think it's very important what the court said here. The court recognized that water service means more than just supplying water. It includes managing a groundwater basin and ensuring ongoing potable supply of groundwater to the entire basin. I would argue that this supports the argument that those who create greater demand and need for program facilities and additional supply share in a greater proportion of those costs. The court found that the charges here did not exceed the portion cost of service because all groundwater well users within the entire basin benefited from the program and therefore should share in a portion of that cost. So essentially that again goes to the issues of what was decided favorably in San Juan. Your alternative supply programs, including recycled water, it's appropriate to share a portion of that cost with everybody within a jurisdiction that benefits from that program. The court also found that property fees need not be established on a parcel basis. Rate makers may group similar users together, and the apportionment is not a determination that lends itself to precise calculation. This is another very important quote, so I'm going to quote again from this portion of the case because I think it's very significant what the court said here. The court said apportionment is not a determination that lends itself to precise calculation. Precise calculation. Given that Proposition 218 prescribes no particular method for apportioning a fee or charge other than the amount shall not exceed the proportional cost of service attributable to the parcel, the agency's method of grouping similar users together for the same rate and charging users according to usage is a reasonable way to apportion the cost of service. A reasonable way to apportion the cost of service. So further they said that there may be other methods favored by plaintiffs does not render the agency's method unconstitutional. Proposition 218 does not require a more finely calibrated apportion. So essentially you're looking at what is reasonable, what is a reasonable means of calculating those costs and apportioning them. So the court basically also looked at, in Morgan versus Imperial Irrigation District, a little bit different. They also recognize that rate making by customer classes or groups of customer is an appropriate means of allocating costs, thereby suggesting that as long as you have apportioned costs within your customer class basis, among the various customer classes, that you have met the standards of Proposition 218, rather than having to go on a parcel-by-parcel basis within each customer class. Court also acknowledged that different users create different costs. Again, if a customer places greater demands on the system, they create different costs, and it's appropriate to allocate those costs accordingly. And then ultimately, the rate-making data does not have to be perfect. Here in this instance, what they had was a number of, not all of their customers were on metered usage, so they had a means by which they reasonably calculated what that usage would be, using various data that they had made and assumptions, as well as from information they obtained from the American Water Works Association. The court said that was appropriate. It was a reasonable method of allocating the costs and determining what those costs are. The data does not have to be perfect in determining those costs. Then most recently we have Moore versus City of Lemon Grove. This case actually concerned a challenge to the transfer of monies from the utility to the general fund. What was at issue here was the methodology, again, used to determine how to allocate those costs. Basically, the fees the court ultimately determined are not easily correlated to a specific ascertainable cost, but the method by which the city apportioned those costs and estimated them was sufficient. They had a rather informal method by which they did that, but the court recognized that ultimately, based upon the evidence before them, the method they used was appropriate. And then ultimately, of course, then the court determined the city satisfied its burden to prove compliance.
Can I ask a quick question? And I apologize for not having read that case. Was just the issue then presented that the utility benefits from the city, and so they're sort of paying their overhead or some cost?
Essentially, there are costs that the general fund incurs on behalf of the utility, and so it was appropriate to basically to pay back the general fund for those services that are provided by the general fund on behalf of the utility. One of the two of the earliest cases governing Proposition 218 challenged a similar issue. That was Howard Jarvis Taxpayers Association versus City of Fresno and Howard Jarvis Taxpayers Association versus City of Roseville. In both those cases, the cities did not have an adequate record to demonstrate the basis upon which they were transferring monies from their utility to their general fund. So this was a step further in that analysis where the court basically looked at the methodology that was used and found that it was justifiable. So we're going to talk about a couple of other unanswered questions first. I'm just going to address this one. Michael mentioned this, and I'm going to mention it again. The court's decision in the San Juan case is internally inconsistent. On the one hand, they said that it was appropriate to have all customers, potable customers, pay a portion of recycled water because they benefit from the recycled project, and that it was appropriate to go back and send that case down to the trial court because they did not feel that the customers who used water in the first tier, where they referred to as the super savers, should have to pay any portion of the potable water, the recycled water program. So on the one hand, they said, all right, they didn't use a lot of water, so they should not have to pay for recycled water, but we don't think it's appropriate that you should have tiered rates, unless you can demonstrate that there's specific demand associated with that and incremental costs associated with that demand. So it was internally inconsistent, and I think that there are issues associated with that.
Some of the other questions that we're wrestling with post San Juan Capistrano is there are many utilities which do tiered rates based on budgets for water use specific to each parcel. San Juan Capistrano has one of the most developed such systems. They started in 1991 in that drought, and they give you a water demand based on the size of your parcel, the amount of landscaping that they think is prudent for that parcel, and the type of landscaping they think is prudent, and they use evapotranspiration factors to meter out your budget. They also take into account the population. If you have a kid, you're supposed to let them know. If you get divorced, you're supposed to let them know, and your water bill reflects the number of people and the amount of turf and the kind of turf. It's a very articulate budget system, and it assumes that different allowances are good public policy and a good measure of what Article 10, Section 2 is trying to get at, and that can be the basis for charging people. Well, that raises the question, can we do that if we're really driven just by what things cost? Because it may not cost any more to give you 17 HCF and your neighbor 13 because you've got one more child, yet the prices will differ. The second question that we're struggling with is, in light of the precision that the San Juan Capistrano panel required of San Juan Capistrano's rate-making record, how much discretion is left? Is rate-making really just something computers and judges should do, or is it legislative discretionary activity? I think it's still the latter, but we may have some trouble persuading that to at least some judges. If San Juan Capistrano is not published, will trial courts follow it, or will they follow Griffith, Morgan, and Moore? The Monterey Superior Court followed Griffith, not least because it's reviewed by the 6th District, which wrote Griffith. And that's all the material we have prepared, but we'd be happy to answer any questions that you may have.
All of this is good. I mean, it's good to hear this, and it's good to hear that they got it wrong. However, we heard in the previous panel, and I don't know if you were here for it, but basically saying that water agencies are not, it's not so much that they think that the San Juan case is correct, but they're terrified of any litigation because it's expensive. And so rather than worry about it, they are just, going to flat rates or whatever it is they choose to do. What would you say to those water agencies? I mean, their fears are not unfounded, right?
We're in the business as public lawyers helping our clients not get sued. The lawsuit itself is a problem. If you're having trouble funding your services, you don't want to spend it on lawyers if you can avoid it. So we don't encourage our clients to take needless risk. On the other hand, the purpose of the city is not to avoid litigation. The purpose of the city or the water district is to provide a public good and public services. And so what I encourage my clients to start with is, what are your public policy objectives? And then let's find the most defensible path to accomplish them that you can. In my judgment, the slide that we put back up on the screen gives a set of tools that can be used to achieve conservation pricing, even if San Juan Capistrano was the law. What's required is a good rate-making consultant and some good legal advice and the patience to listen to both.
And ultimately, again, I would echo that, it is an issue of developing a strong administrative record. More than anything else, as we move forward in this new world, that's what this is all about. When I first saw the trial court decision, my first reaction to it was, oh, this is another Palmdale case where we just don't simply have a sufficient administrative record. The court, however, took it a lot farther and essentially inserted itself in telling agencies, this is how you have to do it. And that's not, in my view, the appropriate job of the court, in a sense. They can interpret the Constitution, obviously, and if the city had gotten it wrong, that's their job to determine, but to ultimately dictate how you allocate costs to a public agency is not within their purview, in my view.
I think what's in essence in the case is the court underestimated how complex this is. And they think you can get to simple, unassailably right answers, which is what judges do. Judges are supposed to get to answers that, when explained, everybody would accept as right. Legislatures have to pick among many right answers. And we believe from our experience, and I suspect you believe from yours, that rate making is legislative, not judicial, and for good reason.
And what can we do as a state board or staff to assist with respect to the advice that you would give your clients on, getting a good consultant, putting together the justification? Is there anything that we can do from sort of a broad technical perspective, providing additional tools?
The League and Aqua and CSAC have given you a combined letter asking you to do three things. One is to assist them with amicus support in court. Two is to assist them with legislative agendas in the building. And then thirdly is technical assistance. Let me get real specific about technical assistance for the moment. Kelly described this idea of peaking as a way of distributing costs. The larger your peak, the bigger the pipe we need to serve you. Most of our costs go into infrastructure and to maintaining that infrastructure. So if a 6-inch pipe would do, but we've got 16 inches because there's a brewery at the end of it, it's the brewery that should be paying for the difference between 6 and 16. That concept is uncontroversial. It's used throughout the industry and it's used around the world. However, it's used to distinguish classes. You distinguish single family from multifamily, from commercial from industrial. Nobody but California has ever needed to make distinctions within the residential customer class. We now do. And there's no industry standard data we can point to that says this is how you do your peaking characteristics. Well, there's two ways to solve that problem. One is to rely on some really smart consultants and some really good lawyers to litigate for a while and generate some published appellate law. In 6 years, we'll tell you what the standard is. If you guys could put out a well-vetted, well-publicized, and discussed, and intellectually sustainable standard that is external to our clients, the very fact of external validation by a disinterested party, or at least not interested in our rates today, is valuable to us. So I think there's an opportunity for your board and your resources in dialogue with the rate-making community and the consultants to support them to come up with a technical assistance document about using peaking within the residential class that will be very valuable.
And ultimately, again, legislatively, I think there is support that you could provide in terms of legislation that's going to define what in fact are costs associated with service. There are a number of costs we've identified. Within each agency, it's going to be different. Those agencies which have one source of supply, it's going to be more difficult for them to demonstrate the ability to establish tiers. But there are these other costs we can identify and work with those agencies to refine how they develop their cost allocations.
Question, is it on? Yeah, a totally obvious question, but wouldn't our conservation regs be an obvious cost?
Oh, yeah.
Oh, absolutely.
Yeah.
And that gets to, water conservation efficiency programs. Any conservation costs associated that you pass on to agencies are part of that.
We can and do assign those costs to the upper tiers. It's just not all that expensive. In San Juan Capistrano, which has a very robust conservation program and has been very successful in reducing water demand there, we still only got a 50-cent spread from the cheapest water to the most expensive. Now, I mentioned to you in terms of legislative strategy a number of things like statutes of limitations and class action remedies that all seem pretty far afield from what you do on a day-to-day basis. But let me make the linkage for you. You started by saying, my clients are risk adverse and they want to go to flat rates so they don't get sued. That risk adversity is a problem, and it is exaggerated by the fact there's no statute of limitations and the class action remedy is available. So if we could reduce risk in that way, it might embolden our clients to accomplish good public policy.
Going back to, I think you had mentioned that rate analysis can look into the future, because the administration is quite concerned about the effect of climate, and we don't really know exactly what it's going to be, but it is unlikely to be friendly to water agencies. It's just, there's going to be lots and lots of variability. And so I had postulated that possibly you could do the marginal costs and look at what it would take to provide the next increment of water. But you mentioned, or storage, sure.
Or conservation.
Or conservation.
And so you were saying that there were ways you could use the rate structure to do that. So do you want to expand on that?
The American Water Works M1 manual, which is sort of the Bible for rate making, and again, that's an externally validated process that we can say, see, judge, somebody other than us says this is how we should be doing it. It says your basic rate making process is to determine your revenue requirement. What does it cost to operate your utility? To determine your non-rate revenues, and you end up with the net revenue requirement. That's step one. Step two is to identify your customer classes. Step three is to identify your functions. Water, you obtain water, you store water, you treat water, you distribute water, you conserve water. And then determine how much each customer class should bear of those functionalized costs. And then you establish a rate structure to get to the end. That's the process writ large. When we establish a revenue requirement, the way we typically do it is we project 3 or 5 years into the future. Relatively few people are doing more than 5. 5 is getting to be a little bit of a sweet spot because there's a statute that was adopted for other reasons that says you can run a set of rates with a cost inflator for 5 years before you need to do a new 218 hearing. So that 5 years is tending to become the node in the data as to when people do this. But there's no logical reason why we couldn't do 10 or 20 or 30, except that the reliability of your cost estimates gets attenuated when you try to look that far out.
And certainly you do a capital improvement program that does look out longer than a 5-year horizon. And when you develop your rates, you are looking to develop them beyond even the 3 to 5 year horizon, building up toward that capital program. So certainly everybody who is doing their rate analysis is looking more than beyond generally 3 to 5 years, knowing what their capital program and other needs are going to be on a going forward basis.
We tend to tie these back to audited financial data, so we do look backward to what we did spend, and then we adjust our historic cost data by those reasoned predictions that we can make. Like if we've signed MOUs with labor, we know what our labor is going to cost. We can make some predictions about power, those sorts of things. But generally, we look backward and then project into the future, and that's reasonable. And the interesting thing about it is, no matter how you predict the future, you will be wrong. We just don't know how.
Both the San Juan Capistrano trial court, at least, as well as the Griffith versus Pajaro Valley management case, those courts both recognize it is appropriate to look at what your long-term program costs are, and that your costs that you incur today for the future are your current costs, and you can allocate those costs accordingly.
A couple of common tools to accomplish the purpose I think you're talking about. One is a rate stabilization reserve where you build up cash when the rain is heavy, so that you can subsidize rates when the rain is not, or cover exceptional costs. So a rate stabilization reserve is fairly common. Another approach is a drought surcharge. We spread our revenue requirement over predicted sales. If you tell us to reduce our predicted sales by 39%, and we achieve that, we have 100% of our costs and only 69% of our sales, and we've got a problem. So drought surcharges are designed to stabilize our revenues even as our volume of sales falls. And that, if it's well designed, kicks in as the drought kicks in and goes away as the drought abates. And that can serve these purposes too.
I wanted to get into a little bit of the indirect cost discussion that a lot of folks are having, because you mentioned peaking and other engineering based estimates, which will take into account pipes, pumps, treatment plants, and assets that are easier to create valuation. But a lot of challenges before us relate to more of the valuation of factors that aren't on the ledger of the water agencies. And I would just like some affirmation that when we talk about development of alternative supplies or other sources of supply, we might be talking about investing ratepayer funds in forestry management in a watershed that provides the source water for that purveyor, or some of the adaptation issues with climate, which to replace shrinking snowpack, we could be going as far afield as meadow restoration in the Sierra Nevada, and being partners in that more river basin planning exercise. We heard earlier from the professor from UC Riverside, how there are these external costs that take into account, but he then gave the SAPA example, Santa Ana, where there's more acceptance of the budget-based approach. And that's in a river basin planning context where these externalized costs are brought more into what it takes to actually deliver the water, and not on a parcel by parcel basis. So do you see, as we try to expand into future 10-year horizons, and is there a pathway within these bullets here in terms of justification of tiers to support these outside of the rate, the traditional sort of pipes, pumps, and that sort of thing, but also to justify costs of participation in basin planning exercises? Really multi-party, helping pay for getting stormwater agencies to the table who have a funding deficit to come up with the multi-benefit solutions that river basin planning, not only in our national context, but international context, are tackling these days.
I would say, and then Michael, please jump in, that ultimately, if it's a cost to the agency that you can identify, those external costs are part of your cost of service. If they invest in them and they're part of that, then certainly I think it's a cost you can allocate.
Kelly's usually more conservative than I am, but we're going to switch roles on this one. I think those legally mandated expenses of running a lawful water utility are plainly permissible. So if the state environmental agencies or the federal environmental agencies require us to engage in environmental mitigation in order to operate our utility, that's obviously a lawful cost. So if your take permit for ocean-going fish requires you to restore a meadow in the Sierra Nevada, you can restore a meadow in the Sierra Nevada. On the other hand, if you're talking about voluntarily undertaken environmental mitigation measures that the utility voluntarily undertakes because they have a more holistic understanding of the resource that they are maintaining, I predict politically freighted waters, particularly in our more conservative communities. and I predict some degree of judicial skepticism. And I would advise a client who wanted to do that to compile a record with really strong science. And if your agency wishes to support that kind of thinking, that's another area in which technical assistance, where you could compile a library of science and some pieces to help people understand the science. One of the reasons we have difficulty in San Juan Capistrano in the trial court is that our record was written by an engineer for an engineer. It was 25 interlocking spreadsheets with very little text. And we drew a judge who was not a math major. No text.
It was a thing of beauty. What do you...
Exactly. And so you need to speak in language that judges can hear, and we've got 1,800 judges in our state who hear differently.
And back to your point, I actually agree with you.
Okay.
The only point would be that I would say that I do think that agencies may participate voluntarily in some programs if they see there's a benefit ultimately to their water system. If it offsets demand, if it develops other things which are a benefit to their system that ultimately benefits their utility customers, I would certainly believe that they could participate. Ultimately, it's obviously much more cost-directed if it's coming from an MS4 permit or some other identifiable cost that's imposed upon the agency as part of their cost of service.
No, that's the kind of situation in which you see people asking for things to be put into consent decrees or cease and desist orders so they have the piece of paper.
Right. They've got a justification to charge for it. Exactly. Environmentalists sometimes experience the water establishment as conservative and hostile. My experience of the water bureaucracy of our state, that subculture, water buffaloes, those folks are by and large pragmatic. They're not ideologically driven. They're just trying to figure out how to get stuff done. And if you can show them a pragmatic set of tools to accomplish your objective and theirs, there's a very productive conversation to be had.
And it speaks to some of the language you used in terms of the different court decisions, which was, it doesn't have to be precise, but there has to be an explanation and connect the dots.
Nexus.
So are you saying that in the San Juan decision, and maybe I'm doing this to help me, but also anybody listening, that the core problem is that parcel by parcel tying as opposed to the broader definition?
The core problem in San Juan Capistrano is that the ratio of prices from the 0 tier to the first tier to the second tier to the third tier was a smooth geometric curve.
Multipliers.
It was rate design that you could do anywhere but in California. And overlaid on that was a justification based on sources that didn't match, because we were using, or that rate study used, the very relatively high cost of net water to explain tiers 3 and 4, but 61% of the water we sell in tier 2 is net water. So there was just a mismatch between the justification and what that record supported.
So then the bottom line, and this is consistent with what I heard, is that the case doesn't make tiered rates impossible at all. It's just you have to dot your I's and cross your T's more carefully. And then what you're suggesting on the legislative decisions are all made in the governor's office. Obviously, we consult, but we have no opinion until the governor has an opinion. I'm just telling you. But this is all very helpful because everybody's listening to this, and we obviously consult. But that there are certain technical pieces of work that we could do, and you've outlined maybe a couple of things that would just be helpful, and whatever we would do or we would do with our colleagues at DWR, of course, who have the laboring oar on the urban water management planning and all of that sort of thing. We just have the regulatory setting and the money, and we have different roles and we like to work together. Would be to get a laundry list of those things down that we could put together that presumably would be things that people within the industry would agree with, and it would just be, here we're stating what the state of the art is, and then folks could use that.
Or not, at their choice. If this is just a toolbox that you're developing,
That makes sense to have a
people
third
will
party.
use them.
Right, and part of the reason for this meeting is to figure out what, you can always do everything, but what were the most important things that we could do to be helpful in this?
And from my perspective, the two things we've talked about today that would most benefit from your technical assistance support is that rethinking of peaking within customer classes. I think that's the most immediate, fruitful path. And then secondly, to the extent you aspire to these broader understandings of resource husbandry, we're going to need some science to do that.
And one last question. This morning on the first panel, we heard from Lester Snow a suggestion that there might be a water fee needed that would be called a Drought Recovery and Preparedness Fund. Now, this was not an emergency reg. This would be something that would be for everyone now, for forever. And so what is, from a San Juan Capistrano 218 perspective, how should we be looking at that
Who would be
suggestion?
imposing the fee? The local agencies or the state level?
He didn't say. It would have to be the state proposing it, but how it would be collected and where it would reside and who would collect it. Certainly we have the energy side that says the locals collect it, but
The legal analysis depends on who charges
Yeah,
it.
that's why I was asking.
If it's an element of local rate making, maybe even a mandated element of local rate making, although when you try to mandate how we make rates, you'll get constitutional sections quoted back to you very quickly. There you go, and we'll find some. We'll borrow some Latinate words from the governor and have that argument. So if it's about us doing it, we just have to demonstrate the costs, and costs that preserve the resource and comply with law and stabilize rates and look to the future, if properly documented, can be recovered.
And what the purpose of the fee is. You have to start, what is the purpose of the fee? What is it being used for? And then can you cost justify it?
At the state level, beyond your authority, if the legislature were to act, they're going to run into a Prop 26 debate if they don't get 2/3 in each chamber, just as the public goods charge on power did, a public goods charge on water would. But a 2/3 vote of the legislature could do almost anything in this area of the law. Getting there is maybe difficult. A simple majority vote out of the legislature to identify services that we are required to fund would probably run into mandates analysis as well. And then the response to that is, yeah, but you've got fee-making power and go do it. So my sense is that there may be an opportunity legislatively, probably not within your purview, although I don't tend to be an expert in the scope of your authority. That's your council's job. There's probably a way to identify a set of services to be valued and provided and charged for. My sense, based on the San Juan Capistrano case, is that the kinds of numbers that are going to be politically acceptable and that would do really powerful things in terms of conserving the resource would still not send a very high price signal to conserve. The good news is that means they're affordable. The bad news is that if you're looking for conservation price signaling, this isn't going to get you all the way there, but it may get you a few, yeah.
And ultimately, just keep in consideration that each fee you add on, you're hurting those customers who are low income. And it's ultimately one of the biggest issues as a result of Proposition 218, where you used to be able to have a low income discount and you can no longer do that. So each time you add on a fee, it has to be not only cost justified at the local level, but it does impact a big segment of society that may not be able to absorb that cost.
That was the justification for the super saver rate in San Juan. The zero tier there is 0 to 6 HCF. 0 to 6 HCF a month is enough for 2 people and no landscaping. And it was intended in many ways to say to the low-income seniors, let your lawn die and water will be really, really cheap.
Mr. Loffer, comments? Another scintillating question following on your fellow moderators? Panel?
I don't do Oprah. No, I think that this has been a solid overview for you all from practitioners in this field, and I hopefully some of the concepts that they've been putting forward are familiar to those of you that I've had a chance to talk with, but there's also a lot of food for thought. There is not one silver bullet, and I think if you were to ask, other than Prop 218 reform, any of the panelists today, whether there was a silver bullet, they would say no. But what you're seeing is, I think, a menu that will need to get built out of different ways to tackle this problem. And what you have heard your staff start to talk about over the last 2 months is trying to put together toolkits. I think both Kelly and Michael have put kind of a finer point on that in the presentations earlier this morning. I think did a good job in that respect.
The opportunity.
No, thank you very much. I'm sure that was helpful for a lot of people. Terrific. Let's move to public comment. We have a number of speakers, great expertise as well. First, we'll have Ronald Stork from Friends of the River, followed by, and we can go for 5 minutes, and then followed by Jenny Gain from the California Urban Water Agencies. Hi, Mr. Stork. Oh, make sure you're...
Now it's on. I was an original signatory of the council's MOU back many, many years ago. And I've also been part of all of the federal and state legislative efforts that have established metering and requirements to use the meter legislation since 1992. I missed the 1990 legislation, just forgive me. But I was a younger man then and doing other things. But I'm condemned to the last 30 years or so. I've lived my last 45 years in communities in California that don't require meters and in fact don't have meters even to this day. So I bring a somewhat different perspective to coastal and Southern California experiences than I would otherwise. I think it's useful to reflect on where the state is on this. The state required in 1990 that all new construction in essentially the smallest of hamlets have water meters, but there is no requirement to use them. And in 2003 and 2004 and 2005, communities that are urban water suppliers or investor-owned utilities serving more than 500 customers, in effect, were required to meter and to use the meters. At the time that the legislation in 2003 and 4 passed, applying to public agencies, they were required to bill by volume. And if you're holding a workshop on conservation pricing, what is that? Well, it's at least having a meter and billing by volume and arguably increasing unit costs as you use those meters. The legislation, however, was changed in 2009 to say that utilities could use fixed charges in their bills so long as they had a program that their rate structures would actually promote conservation. That was undefined by the legislature. To some degree, it was expected that the council would define it. The council's definitions at this point are hazy. The BMP 1.4 says, well, any of these options that you choose may be considered to be conservation pricing. They don't say they are conservation pricing. And indeed, many of us who look at the structure of BMP 1.4 note that option 2 permits utilities to essentially apportion their volumetric versus fixed charges on the basis of their degree of fixed charges. And you've heard today that a typical utility may consider the 80%, and I've heard as much as 95% of their debt burden is indeed that. So at least with regard to the option 2, one could hardly call that conservation pricing, and I simply don't. The matrix is something that we have in the council have come up with. We're relatively proud of it. I do note that that almost all the points for that second tier are for having a proportionality test that means that the more water you use, the less you pay per unit volume. So I think that it's helpful for you to recognize that perhaps there is something that the board can do, as well as the legislature and obviously the governor. One might be indeed to begin to require meters and volumetric pricing for smaller utilities. but they use a relatively small amount of water. Nevertheless, there's an equity argument there. The other is to try to define better than the legislature and the council have done so far what indeed conservation pricing is. That's what this workshop is about. I think you've covered these issues. I think you intuitively know about these issues. And I think that there is indeed a vacuum that this board can serve. And I have timed my talk precisely. Are there any questions?
Oh, thank you very much, Mr. Choi. We may have questions later, but we'll roll through the speakers.